For joining us for our first meeting in January of 2023. That's going to take me a while to start writing that stuff, I'm sure. So please forgive me if I mix it up a couple times here. My name is Rebecca Badoon. I'm the president of the WPA board right now. Jack has hosted this event, but is not actually with us. So you'll see Jack up there. That's actually one of our newest board members, Jenny Skanke, who is joining us and leading this today. We also have another new board member, Kelsey White. So congratulations. We're looking forward to working with these two individuals. I just want you to know that you cannot unmute yourselves. So if you have questions throughout the presentation, looks like some of you have already sorted this out, but you can use the chat feature. I believe you can either send it to the entire group, or you could send it to either me or fake Jack, if you will. Try not to send it to Ken and Ben. They're probably not going to be monitoring it, so they won't see it in all likelihood. With that, I will introduce our speakers today. They are both with Bowser. We have Ben Meyer. He's a wetland specialist who's been with Bowser since 2014. Ben is a co-lead in the state's Minnesota Wetland Professional Certification Program that provides wetland delineation technical and program administrative training. Prior to joining Bowser, he was an environmental consultant for 13 years, conducting wetland delineations, permitting, and other natural resources work across the upper Midwest. He has a BS degree in biology from Northland College in Ashland, Wisconsin, and a master's degree in soil science from the University of Minnesota. He is a Minnesota certified wetland professional, a professional wetland scientist, and is a past president of the Minnesota Wetlands Professionals Association. And with him, we have Ken Powell. Ken is Bowser's Wetland Conservation Act Operations Supervisor and has been with Bowser since 2008. He has worked directly with the Minnesota Wetland Conservation Act since 1994 and previously worked as a private environmental consultant, as a wetland specialist with a local government unit in Minnesota. He is a graduate of University of Wisconsin-Stevens Point and Kansas State University. So with that, I'll hand it over to them.
Thank you, Rebecca. Welcome, WPA members. Happy New Year. This is Ben. I'm just going to start off the presentation just with a few slides, just some informational type slides, and then the bulk of the presentation will be Ken and the rulemaking updates. So next slide, please, Ken. So here's, like I said, here's what we're going to cover. I'm just going to give a couple MWPCP updates, give you some teasers kind of on calendar type things, dates, things to think about for the upcoming year. We'll have a quick slide on the functional assessment, and then Ken will get into the rulemaking. For those who haven't seen or been on our website in a while, there's a updated map of wetland specialist work areas there on the right. That's on our website. So, or those who maybe have started working in the last couple months, just so you know, that's how to contact your local wetland specialist. Next slide, please. Okay, so this is a refresher for a few of you that were at the Minnesota Water Resource Conference back in October, but I'll bring it up again because I think a bunch of the membership wasn't there. So just some reminders. Because of the COVID policy, temporary COVID policy, those who opted in under the old University of Minnesota program, the WDCP, is about 360 individuals. You're on this temporary COVID policy that your renewal period is the end of this year now, so December 31st, 2023. And you'll only need 12 credits. That's that temporary COVID policy. And half of those credits essentially now can be from online credits, such as this class. Going forward, for those that have renewed, or not renewed, those that have become certified under the new program, would be since 2021, I guess. You will now need, and those that renewal once you're up at the end of this year going forward, temporary COVID policy is gone. It'll be 18 credits for that 3-year renewal period. So example, if you're under the new program in 2021, you'll have until the end of December 2024 to get those 18 credits, 6 of which still can be online. And then I guess next slide, please. So some more details. This is what we're proposing. We have some of these locked in already. This is kind of our major big picture outline of the MWPCP training for the coming year. So those that have been involved in the last couple of years, especially with the pandemic, we started to do this February 2 half-day virtual trainings, mainly on WACA regulatory subjects. So you'll see that again coming up soon. There's no registration. We'll basically send out a blast email with a WebEx link to come and join those. We've had really good attendance across the state. I think we've had in excess of 170 people attend those in the last couple of years. So look for that coming up. That'll be our first training basically to kick off the season in February. Then we're looking at having a one-day kind of really WACA regulatory heavy training in St. Cloud. We're looking for those two-day regional trainings. We're trying to, again, spread around the state compared to what we did last year. So we're looking at one in the southeast in Rochester and essentially one in kind of the northwest or central part of the state in Fergus Falls. We're going to have a delineation kind of specific type delineation refresher in Spicer in August. We haven't really done kind of a delineation refresher that focuses on the 3 parameters for a whole day in about a year or so. So that'll be good for people. And then our typical 5-day basic technical and regulatory class. We'll have the one in Arden Hills in June and the one in Brainerd in September. And then we're going to have a plant ID class. People have asked for those. So last year, if people remember, we had an advanced hydrology class. So this year we're kind of focusing on vegetation. So we're going to have a plant ID class, 2 of them in July. One will be in the metro and one will be in Brainerd. And then an FQA course in Shoreview in June. So that's just a one-day class. So look for that announcement to come up. We hope to get a kind of save the date announcement by the end of this month. So that's actually coming up fairly quickly in a few weeks here. So look for that. It'll have the dates, the location, times, things like that. And then the registration will be about a month later in early March. So you'll have some time to look at the dates and get approvals or whatever that you need to do for that. And then we'll open it up like we did last year. We'll open everything up at one time for all the different courses for the entire season in March. So look for that. Next slide, please.
Hey, Ben, real quick, we got a question.
Yeah.
Is Bowser keeping track of your the ones that you guys are leading, the continuing ed credits?
Yeah, that's a good comment. Yes, so anything that is sponsored by MWPCP, those that have come in person to those trainings, you'll know that you've signed in on a sign-in sheet. We keep track of all those when we're the sponsor or the host. And so you don't need to prove to us, right, that you've taken those. Most people that were certified and are up for renewal in this year, gotta remember it's 2023, should have gotten an email that said you are short credits and you will need credits for this year. If you didn't get one, I think you're probably fine. That's a perfect segue question for the slide I have up now. If you have questions on, do I have enough credits? What's my status? You can email those to Amy Waters. We basically, there's a I should have put that on here. There's an MWPCP specific, David, maybe you can throw that in the chat. The MWPCP at bowser.state.mn email address and request what your status is. So all those online, so they're, look on our website under, so additional information, WACA program and guidance and information on our website. We'll have a lot of information if you've missed out on this in the last couple of years. We have a lot of online resources now that we actually didn't have, I would say, a few years ago prior to the pandemic. So there are, thank you, David. So there are topics of the week. There's some updated guidance that have been on there. So if you haven't been on our website in a while, I just encourage you to go look at that. And then we do have some online trainings, videos that were recorded live and edited, or actual modules that were recorded for those that maybe need a refresher, new employees that haven't been able to get to one of our in-person trainings yet. Those are good places to start. And as always, feel free to reach out to David Demmer, my co-lead in the program, or myself if you have any programmatic questions. And then you'll be dealing with Amy mainly on the upcoming year for registration and payment and things like that. If anybody else has questions on the MWPCP stuff, maybe we could take it quick now. Otherwise, I will stop talking and hand it over to Ken.
We good?
Nothing's popped up, so I think you're good
All right.
for now. We can always take them at the end if somebody thinks of something too.
Sure. Yeah. Before I get into rulemaking, just a quick update on the functional assessment initiative. I think last year at the forum here, we were in the process of doing an RFP for consultants, and that's all been accomplished. We have a consultant on board. We've been working on the new functional assessment initiative. And again, this is, if you're not familiar, this is a Minnesota and Wisconsin cooperative thing. And we do have an EPA grant that provides funding. And we started in 2021, and we're kind of in the middle of it right now. We're working on some draft questions for the new functional assessment method. And hopefully we'll be posting some draft documents here this spring for peer review by others. And we'll send out a communication when that happens. And we have on the Bowser website is the Functional Assessment Initiative webpage. We're just housing it on the Bowser website. So just a little blurb about that. Nothing major to report here other than we're just kind of in the middle of it. So Wetland Conservation Act rulemaking. Try to give you an overview and cover many of the topics that we've covered with our advisory committee so far. Just as a starter, this is our statutory authority to do rulemaking, and as you probably all know, Bowser is responsible for promulgation of the WACA rule, and our local governments are primarily tasked with implementing with Bowser oversight and assistance. So a little background, rulemaking was first initiated in 2015. And just to back up even further, the last rulemaking that we went through for WACA was in 2008, 2009. And then there was some statute changes that occurred in 2011. And at that time, there was a ban on all state rulemaking that lasted for several years. So hence the delay until 2015. There was official publication and request for comments in the state record. We had a couple advisory committee meetings in 2016. There was a WACA report to the legislature in which we worked with, again, an advisory committee, and there were a couple public meetings regarding that report. We did assemble a technical review team, and this consisted of local government unit folks from around the state and consultants that worked in different areas of the state. We had 3 meetings in 2018. And then 2019, we were tasked with the 404 assumption work, which many of you might be familiar with. And that was sort of all hands on deck to meet the legislative requirement for the assumption work. So that occurred 2019 through 2022. And really that's when rulemaking significant progress kind of came to a halt. We just didn't have the staff to do both of these things. So now that's, we of course have been working on different aspects of it that will contribute to rulemaking, and I'll go over some of those things here. And then in 2022, we reissued a request for comments and basically renewed the rulemaking process. And now in 2022, we've had 2 wetland advisory meetings. I think it was August and September, or August and October. So that's kind of where we're at right now. And here you can see in the, just again, that initial request for comments in 2015, the second request in 2022. We do have a rulemaking page on the Bowser website. So all the comments that we received, I think 19 letters in all, are posted on the website. But don't be dissuaded by the comment periods. We'll be accepting comments anytime during the rulemaking, much the way we did back in 2008, 2009. So folks can always submit comments. Folks can request a meeting with myself or Les or any of us to discuss any aspects of rulemaking. We'll be glad to do that. Those are actually probably the more productive sessions than some of the bigger meetings where it's hard to kind of get down to the specifics. So here's generally the process graphically. Of course, we're Bowser Wetland staff. We're producing proposals and ideas, running them through some technical review, and this primarily referring here to the agency folks, other agencies, DNR, PCA, the Corps, and also that technical review team that we had convened in 2018. Then we go to our Wetland Advisory Committee, which I have a slide here next on that. And then through that, we develop, at some point, these, actual language proposals for changes to the rule. Once that sort of process happens, then we go to our Bowser Wetland Conservation Committee. And all that is if you're familiar with the Bowser board, we have 20-some members on the Bowser board representing agencies and local government units and citizen reps, and they form different sort of committees, and one of them is the Wetland Conservation Committee. So our proposal will first go to them, and they make a recommendation to the full board as to whether accept or deny those recommendations. And after all that, then it actually starts the more formal administrative process, which is I don't have enough room to show all the steps involved in that. Let's just say it's very intensive and long. All that process and procedure is in this manual here, which I've clipped the cover, the Minnesota Rulemaking Manual. It's about, I think, 400 plus pages. So it describes all the requirements, and it has a bunch of recommendations. And there are many different ways to approach rulemaking. After I've went to a couple seminars on this, and I've read, not all of it, but a lot of it. And the things that we do for WACA and what we did in 2008 and 2009, even though the requirements are a little different now, is basically as much as you can do, pretty much. There are lots of things that can be skipped and are at the discretion of the agency, but we generally are not skipping any of those. So that's why it takes so long. And we run it through this whole process. And then once it gets to this administrative process, then we have a bunch of other folks involved: the governor's office, the legislative leaders of both the House and Senate, the Attorney General's office. We have an administrative law judge that reviews it. And there are a couple other people thrown in there. So all these things have to be vetted even after all this, they're vetted more publicly into these other entities as well. So. Here's our advisory committee. I don't know that this is completely up to date. That's the membership. Generally, the agencies or the entities that are represented stay the same, but some of the representatives kind of fluctuate here and there. But basically, you can kind of see the different environmental and other kinds of entities that are on the advisory committee. And these are pretty much the same ones that were on the committee back in 2008, 2009. The last time we did rulemaking, they were pretty much on the committee for the 404 assumption and for the legislative report. So what's the scope of the rulemaking? So we have statute changes related to WACA from 2011, 2012, 2015, and more recently 2017. So some of these statute changes can just simply be incorporated into rule as is. Some of the statute changes require substantial additional work, and some of the statute changes just really don't warrant any change in the rule. Not every statute related to WACA is in rule or really needs to be in rule. And we'll talk about some of those as I go along here. We always take the opportunity to do other miscellaneous changes to improve efficiency, effectiveness, et cetera. And we just kind of do those on a case-by-case basis. And we'll talk about some of those today. And just to kind of throw out there that we have no hidden agenda. Sometimes there's this, oh, Bowser's trying to sneak something by. Believe me, as many people as look at this, there's nothing going to be snuck by anybody. So we've been as open as we can be about this process, and we'll continue to be that way. So I think the first part is a little tedious, but really it all starts with the actual statute changes that occurred from 2011 to 2017, which is really the basis for everything here, plus some of those concepts that were addressed in the legislative report back in 2016. So just kind of, these are somewhat in chronological order. So see, these are some of the older statute changes dating from 2011, and then towards the end here, I'll get to the 2017 ones. But just to kind of highlight, for example, this one for wetland banking projects established for replacing impacts under a permit to mine. The Commissioner of Natural Resources, in other words, DNR Lands and Minerals, are the approving authority for any wetland banking projects associated with the permit to mine. This has been the case for many years. Again, we just need to codify that in the rule language. The statute also gave us the ability to establish fees for single user banks, and this again is primarily related to those mining entities that are generating large amounts of credit, using large amounts of credits for large projects. And so there's a different fee schedule for those single users. This was a change to the noticing, and again, this is something that's been in place for many years now, but it just has not, has not been put into rule yet. But if you recall, there used to be a application. I'll just put them both here. Within 10 days, receiving an application, there was this 10 days, which conflicted with 1599, which had 15 days. So pretty much everything else in terms of noticing for the WACA decisions followed 1599, except for this one 10-day provision, which was sort of odd. So statute eliminated the 10 days, and just said all the application procedures must follow 1599, just to make it more consistent. So we'll be striking, I think this language here is pretty much what's in the rule, so that will be struck, and we'll replace it with the new 1599 procedures. Some of you may remember back in the day, all local government units were required to have their own appeals process, and that the statute and rule required that folks who wanted to appeal WACA decision would first have to go through that local appeals process before they could appeal to Bowser. Well, that was struck, and now the appeals go directly to Bowser unless the local government unit chooses to have its own local appeal process. Some local government units have kept theirs or established theirs, but many do not, it's my understanding. So most of those appeals just come directly to Bowser. There was also a change regarding the validity, the length that a WACA decision is valid. So that was previously 3 years, and now that's been changed to 5 years, in part to match up with typical permit from the Army Corps for Section 404. Before, in order, Bowser would go through and determine whether a particular appeal would be granted, so that it would be heard by our dispute resolution committee. Sometimes we get appeals that really have no merit. You know, there's no information provided or what the basis of the appeal is, and those are typically denied. So, so what this did was, instead of bringing all these to the board, it allowed now the executive director or a member of the dispute resolution committee to make a determination on whether to grant the appeal or not. So it did a little streamlining, and this has been the case for, again, we've been operating under this for many years. So this is another instance where it's just simply changing the rule to match the statute as it's been implemented. Prior to this statute change, folks could appeal WACA decision, but there was really no mechanism in place to appeal a restoration or replacement order for a violation or a potential violation. So this statute change allowed a process for folks to appeal those orders, and you know, ever since that occurred, these are probably the things that are most appealed, more so than WACA decisions. So, and another thing that is pretty easy to incorporate into the rule, since we've been doing it anyway, because it took effect once the statute was changed. Here's another one that we've been implementing for many years with the statute change, but it's not in rule yet. If you recall, when preservation was first introduced as an action eligible for credit, up at greater than 80% areas in Minnesota, that was for some reason limited to wetlands owned by the state or a local government unit. So the statute change then just eliminated that requirement that the wetlands had to be owned by the state or a local government unit. And of course, since that time, we've had several preservation projects that have been approved that are on just private land. If you're familiar with the agricultural portion of WACA, there are some differences in replacement ratios, the sequencing requirements. If you're on agricultural land, one of the requirements previously was that if you utilized any of these sort of advantages of doing stuff on agricultural land, then you couldn't convert that land for 10 years, and that's still the case, but it did require that a deed restriction be placed on that land. And so that was struck. The deed restriction can still be required by a local government unit, but it's not mandatory in statute. No. So we're going to have to go in and change that language from that's in the rule currently. This is some language cleanup more than anything here. Some of you might be familiar with our what we call the Ag Bank exemption. So these are folks that are in the farm program complying with requirements of the farm program under certain conditions. They're exempt from needing a replacement plan approval from local government unit if they're using the agricultural wetland bank. And that was previously, I mean, that obviously was allowed in our previous statute and rules, but the language was a little outdated. So there was a change here to reference a memorandum of understanding and agreements between the board and the Department of Ag and NRCS. So we'll have to do a little bit of adjusting of the rule language, but it doesn't really change the outcome. It's still an exemption consistent with whatever memorandum of understanding that's developed. I didn't put in the changes to the de minimis just because it takes up too much room, and but basically there was a kind of an overhaul of many of the de minimis amounts. I can't remember what year now off the top of my head. Was it 2011, 2013, somewhere back in there, 2015 perhaps. And of course, we've been operating under those new de minimis amounts for many years now, but it's just a matter of putting those into rule. We are kind of flirting with maybe using a table that might be easier to, I guess, locate and figure out what a de minimis might be for a certain project. Those of you who have looked at the de minimis, it's very confusing and detailed if you're working in multiple areas. All right, so here is one of probably 4 or 5 different statute changes that basically give Bowser the authority to establish an in lieu fee program. So this is one of the first ones. It doesn't actually say in lieu fee, but the ones you'll see later here as I go actually call it an in lieu fee program. But this was the first one that allowed the board to establish a program which may include provisions allowing monetary payment to the wetland bank for impacts to wetlands, and it restricted it to agricultural lands and greater than 80% areas and public roads. So now those restrictions are not included now, or they've been overridden, I guess, by subsequent statute changes. But this was one of the first ones that you know, when Bowser was given that authority to do an in lieu fee program. You can see here legislation or statute regarding the assumption of 404. This is that directed us to do the report and gave us the authority to assume 404 in statute. But of course, that, as you know, hasn't occurred. It's just kind of in a holding pattern at this point, pending any future legislative action. So here's a provision that we are specifically not going to be tackling in this rulemaking, and there are some reasons behind that, which I'll talk about. But this directed the board in consultation with DNR and other agencies to identify high priority areas for wetland replacement, and this stems from the legislative report, which was really focused in 2016 on improving wetland mitigation outcomes. And one of those was to identify, again, high priority areas for replacement that would maximize wetland functional benefits. And I guess just in a nutshell, the reason that we're not proposing that to address that in this particular rulemaking is that we're working on finishing up what's called the compensation planning frameworks, which are essentially prioritization of mitigation plans for the different bank service areas of Minnesota. And we're doing that for our local road program primarily, but we plan to use that information to help inform and help develop these high priority areas. But I have a slide here later on that shows where we're at. We're getting close to being done, but we're not going to be done in time to then take that information and identify high priority areas with our advisory group and others. So this will be for a later rulemaking. Note in here, we did get statutory authority to establish easement stewardship accounts and charge fees, which we've been doing for years now. So, it's basically a way to fund the stewardship of those conservation easements, in particular for our program for the WACA, for those wetland bank easements. So that's something that won't be in rule, but that's something that, of course, is needed if we're going to follow through on our monitoring and stewardship of our conservation easements. So here's the second reference, statute to in lieu fee program, where they actually define what it is. And this is another statutory change related to what I had just talked about, the high priority areas. So it says the board must establish replacement ratios and bank service area priorities to implement the siting and targeting of wetland replacement and encourage the use of high priority areas for wetland replacement. So, you can think about, well, what sort of, how would that play out? And that would mean either folks who have high priority wetland restoration areas either get more credit for those, or else folks that are use credits or mitigation from high priority areas would get a lesser replacement ratio, one or the other, or some combination thereof. But again, until we identify what those high priority areas are, we really cannot, talk about the siting and targeting of those until we kind of have a handle on. Most people want to see what those are before they weigh in on how that would work. So another thing that'll have to wait until we identify those areas. Some of this in here is like this particular one is really statutory cleanup. That's how I refer to it. It's nothing really that's going to affect the rule. There was a portion in statute here that talked about restoring or creating wetland areas. And what's problematic about that is, of course, we have things like ENRV, or exceptional natural resource value, and we have preservation projects, which are also used to replace wetland impacts. So, so basically this just restoring and creating wetland areas was replaced with actions that provide at least, so actions being, whatever those approved actions we have in rule for replacement, which could include preservation, ENRV, etc. So here's another one. There's a little bit of a cleanup here. It says that basically says modification or conversion of non-degraded naturally occurring wetlands from one type to the other are not eligible for, and it used to say enrollment in the State Wetlands Bank. More broadly, they just basically aren't eligible for wetland replacement, period, whether they go into the bank or whether they're used for project-specific replacement. So again, nothing that really affects the current rule. It's just more of a cleanup of the statute where this was, for whatever reason, specific to a wetland bank and not to project-specific replacement. And here's basically a statute change to the previous statute change, which now talks about and names in lieu fee programs. So got rid of the restriction on agricultural land. Just basically gives the state the ability, or Bowser the ability, to to administer an in lieu fee program. And it states that that in lieu fee program must conform with Code of Federal Regulations, which is basically the federal mitigation rule. There's provisions in the federal mitigation rule related to in lieu fee programs. Here's one that we'll talk about in detail more here in a little bit. So in this statute change, the statute identified those decisions that the local government unit must make, and those replacement plans. It used to have wetland banking plan, exemption, no loss, etc. So that the wetland banking plan was struck, and then sequencing was added. So what this does, I guess the implications are that we could, in rule, have a different sort of approval process for wetland banks as opposed to like replacement plans, exemptions, etc. So we have talked to stakeholders about that, and I'll go over some of those options that we're looking at, and I'll talk about some reasons behind, why we might want to have somebody else approving those banking plans. This is again another provision that's not really something that we're going to see in the rule per se, but it is a good thing to have. It gives Bowser the clear authority to acquire land, purchase easements, enter into agreements, establish an in lieu fee like payment, and hold that money in a special account. All those things are necessary. If Bowser proceeds with an in lieu fee program, we can't just take in money and create an account. We have to have statutory authority to hold that money for a specific purpose. So this is what that statute does. It's another cleanup item here in statute. Basically, the statute before said that in a roundabout way that the restoration, enhancement, basically wetland replacement, must be completed prior to any draining or filling of the wetland. And of course, as you know, our process is that for those folks that are doing project-specific replacement, that they can, once approved, they can do those, both the replacement, construction of the replacement, and the filling concurrently. So this was struck to allow, at least in statute, for that to occur. This statute change stems from the 2016, well, actually before that. Those of you around may recall a Northeast mitigation report that was done many years ago. I can't even remember the date anymore, but that effort was a multi-agency effort to try to figure out solutions for the lack of available wetland bank credits in Northeast Minnesota, or basically the greater than 80% areas of the state. And so one of those, as part of those recommendations, there were other things that would enhance natural resources that were recommended as potential solutions, because there weren't very many of the traditional sort of restoration opportunities up north. And so one of those was restoration and protection of streams and riparian buffers. Now, of course, since that study, we actually do have quite, a fair number of banks and available credits in the Northeast. So incorporation of some of these things is, I guess, less urgent at this point, and hopefully we won't need those, because the more traditional wetland restoration certainly fits better with the program. But these are things that, because they're in statute, that at some point we will want to incorporate ways to make them real as potential replacement opportunities. But at this point, we're not planning on developing those in this particular rulemaking. So they might be in a subsequent one. This particular statute change gave the board ability to assess fees associated with establishing conservation easement, and we've been doing that for a number of years. And again, that helps fund that sort of legal process of reviewing and establishing and recording easements. Here, again, what I just talked about before, the addition of different means to replace for wetland impacts. So here's the riparian buffers again. I also have watershed areas essential to maintaining important functions and sustainability of aquatic resources. So a couple more potential actions eligible for credit. Of course, just looking at the language here, those are pretty broad. So a fair amount of work would have to go into actually defining what these are and how to credit them and things of that nature. So again, something that was important, I guess, at the time, back when we didn't have the credits in the Northeast, but not as urgent at this point, and we're not proposing to do anything with rule at this point. So now we're into the more recent changes, I guess more recent 2017. So a big one here that occurred, I'm sure most of you are familiar how the state is divided up into 3 basic areas for WACA. We have the greater than 80%, so greater than 80% of pre-settlement wetlands remaining, and we have a 50 to 80% and then a less than 50. And so those are based on county boundaries. So each county was determined to be greater than 80, 50 to 80, or less than 50, and then basically a line was drawn. And I'll have some maps here to show. So what this statute change basically said is for purposes of wetland replacement, not de minimis exemption stays the same. You know, it's a certain amount if you're in a 50 to 80, less than 50, greater than 80. But for replacement purposes, it says that these areas can be defined based on a bank service area. Here's a change that's related to the permit to mine. Project-specific wetland replacement plans submitted as part of a permit to mine may include surplus wetland credits to be allocated by DNR to offset future mining-related wetland impacts. So again, it allows those mining companies that are working directly with lands and minerals in their permit to mine to basically have these extra credits available for other mining projects without going through the more formal banking system that we have here for the other types of impacts. This requires so the commissioner, or other words, DNR Lands and Minerals, they must provide notice of application for wetland replacement under a permit to mine to the county in which the impact is proposed and the county in which the mitigation site is proposed. And they've been doing that for a number of years, but we'll just have to get that language into the rule. Oops. This particular one is, although it doesn't say permit to mine, but it is related primarily to mining projects. So a lot of the mining projects, there are some others that this could apply to, but a lot of the larger projects are mining projects, and they would have to go through an EIS process. And in that process, you know, which may take years and years, typically they will identify a mitigation site or a replacement site. And the issue that, I guess, potential issue that comes up is they could get through this long process, and then lo and behold, there are opportunities for mitigation that say are closer or preferable than the one they had initially identified. So what this says is, well, wait a minute, you can't have us go through this long process of of evaluating them through an environmental impact statement, and then require us to sort of reevaluate our priority just because conditions have changed. So that's essentially what this statute does. I don't know that it'll come up a lot. And there may be some difficulties depending on the situation that arises here, but that is, I guess, in a nutshell, the reason that the statute was added. A couple provisions that were added, I think, that are specific to DNR. Whoops, hitting the button here. One regarding calcareous fens. B was added, allows DNR to allow water appropriations that result in temporary reductions in groundwater resources on a seasonal basis under an approved calc fen management plan. Not sure, if this is something that DNR is going to want put in the rule or not, but it is something that they can utilize and allow some flexibility if there's a situation where folks are proposing to do some temporary dewatering that may affect the calcareous fen. And then D was added to provide some flexibility for projects that may affect a rare natural community. And if you remember, under WACA special considerations, there's a number of them listed there, and it basically says the LGU cannot approve a replacement plan if certain things are affected. One of those being a rare natural community, and it basically is pretty, I guess, draconian. It just says you just can't do it. You can't. There's no flexibility. There's no way to mitigate. Whatever, that's the implication of the way it's written. So what this does is provide some flexibility, or gives DNR the ability to consider measures to mitigate adverse effect on any of these rare natural communities. I kind of view it as similar to, say, if the project will affect a threatened and endangered species. So DNR could go in and they could identify some mitigation measures, and they could issue a takings permit for those T&E species to allow a project to go through, but then get appropriate mitigation. But under the way the rule is written now, there really is not that option the way it's written for the rare natural community. So this kind of opened that door to allow that to happen. And we're working with DNR to figure out what kind of language we want to put in the rule to make this real and active.
Hey, Ken.
Yes.
It's Jenny.
Hi, Jenny.
You said that this would allow the DNR to consider measures to mitigate, but actually that responsibility still does fall to the LGU under the replacement plan. But the DNR has or could play a role in giving an opinion about whether that mitigation would be adequate.
Yeah. Yep, that's a good point.
Thanks.
I would say that for the most part, most of those LGUs would rely on DNR to provide that expertise. Most of these communities.
Yeah, and the DNR just has to step carefully because the rules and statute give the authority to the LGU, but definitely the DNR / me would play a role in consulting on that.
Yeah. Yep. Good points. And I say, Bowser, we're working with Jenny to come up with some rule language. There is some guidance. There's a guidance document. It's on the Bowser website. It's a joint DNR Bowser guidance. It's been around for a number of years, and we'll be, presumably taking some of the information in there to help, write this portion of the rule to incorporate this statute. A couple other things these are things that probably will not be incorporated into rule. At least we're not going to propose to do much. They're still effective, but they don't really have a lot of utility in terms of putting them in the rule. This is basically a disclosure thing. I believe there was an incident at some point number of years ago now where somebody felt like they were being unfairly treated by a member of the TEP panel who happened to also manage a bank in another area of the state, or had a financial interest in another bank in the area of the state, and they felt like they were not being treated fairly because of that, even though I believe the specifics of was that it was a completely different area of the state, so it wasn't really competing with the other bank of interest. So, but anyway, it just requires them to disclose that they have an interest in another, for example, wetland bank. Here's a provision. This again stems from a case many years ago now, but basically somebody had a violation, a deed restriction was recorded, I believe by DNR enforcement on the property, and then they eventually worked its way to court, and the landowner ended up winning, and there wasn't any requirement, so that the DNR just kept the deed restriction on the property. So this resulted in some complaints and eventually this legislation, which said, look, if they win in court and there is a deed restriction, then you have to remove it. Basically what it says. It's come up once that I know of, but again, something that not sure if, what we need to do in rule, if anything, but it is something that applies regardless. Okay. So here's more about replacement siting. So essentially what this change in statute did is, as you recall, I just mentioned we have basically 3 areas of the state, greater than 80, 50 than 80, less than 50. So what, for purposes of replacement, the statute says now we just have 2 areas. So there's a greater than 80 area and a less than 80 area. And this got rid of that sort of 50 to 80% area, and I'll show you more graphically what, how that might be viewed as a benefit by many. And then in the case of siting, if you recall, the siting priority order went minor, major, watershed, then bank service area, and then another bank service area. What the statute says now is if you're using bank credits as your mitigation, then you can skip these first 2 and it starts at the BSA. That's, in a nutshell, that's what it says. And you can kind of see, if you're familiar with the criteria for moving down the priority order for siting, this is it. And if you look at trying to evaluate banks, I guess it would be a problem if we had a bank that didn't meet any of these criteria. I think these criteria were developed, well, I know they were developed at a time when all the mitigation for the most part was just done project specific. So it made sense, you wanted to make sure that they were, before they, moved out farther away from the impact site, that they would, have to show that they, that the site closer didn't meet one of these criteria. But if we're doing our job right in terms of the bank plan reviews, and when we're going through that bank review process, I mean, all the banks in a bank service area should meet these criteria, which seems to make sense, so that, then that bank, once it becomes established, it can service any and all impacts in that service area. So that's, sorry, that was a long slog, but I wanted to show basically all the statute changes from 2011 to 2017. You can see that there's a lot of stuff in there that doesn't result in a change or minimal change, and things that we have been doing for a number of years. So those would be fairly straightforward. So it's really down to just a few key items that will take some work and trying to figure out how we're going to do those in rule. So a couple things I'll just run through quickly. I'm not going to go into as much detail as I did for the advisory committee meetings. If you want to hear all the little more detail, those meetings are on our rulemaking webpage, and there's all the PowerPoints, which are similar to this one, have a few more slides, and then the recorded presentations are there, so anybody can listen to that. So let's talk about bank service areas. I think it's easier just to cut to the map. So, so here's our current division. These are county-based lines you can see here. So everything to the right here is greater than 80. This stuff in the middle is a 50 to 80, and of course everything outside here is less than 50. And so basically what WACA says is, like, if you impact something in, say, a greater than 80, and you can either replace it in a greater than 80, but you can also replace it in a 50 to 80 or a less than 50. But if you're in a less than 50, you can't go the other way. You can't replace it in a 50 to 80 or greater than 80. So kind of puts folks who might have, say, a bank in BSA 7 in a 50 to 80. So let's say if their bank's here, so they can sell in BSA 7 to from here, this line, that way, but they can't sell this way. So essentially it cuts off half of their market area just because of these county-based lines, if you see what I mean. And it creates problems pretty much all up and down here, which is one of the reasons is that the statute got rid of the 50 to 80 area so that we only deal with two areas. And then also it said that we can also arrange these breaks between greater than 80 and less than 80, or the break can follow watershed lines or BSA lines rather than counties too. So we sat down in 2016, 2017, somewhere around there, and sat down with the Army Corps of Engineers, DNR, and we went through a process of trying to sort of rearrange some bank service area boundaries to sort of accommodate sort of this new greater than 80, less than 80, and the ability to follow those boundaries, to follow BSA boundaries. So we looked at watershed boundaries, ecological sections, land use, a bunch of factors that would influence or could influence where we do bank service areas. And just looking at, pulled this up at the beginning just to see where our original bank service areas came from. And you can see a lot of liberties were taken here. So these are hydrologic unit code, 4-digit code areas, and you can see, and I wasn't around at the time that they formed the bank service areas, and I've never really heard a good story about how they were formed, but you can kind of see in this particular huck, which half of it's in North Dakota, but I guess somebody just decided it was too big, so they, basically drew a line along here and said, okay, well, that's going to be, 3, and this is going to be 4. Down here, we have a couple watersheds that go to the Missouri, so those were lumped. Let's see, 1023 and 1017 were lumped together. This one was combined with these 1, 2, three different ones. So basically Bank Service Area 8 is a combination of portions of 4 different Huck 4 watersheds. Then in the Mississippi one, you can see they must have concluded the same thing as they did here. They said, well, this is just too big, so they cut it in half. And then you can see our Bank Service Area 6, which is by far our smallest service area, and that's St. Croix. And of course, it's small to begin with, but then you have the state line through here, so we end up with a very small service area. And traditionally, it's been difficult to have enough credits in there for applicants. We also took a look at these ecological section boundaries the DNR had produced. You can see there's a number of those there. And we worked through and identified some key watersheds where we thought that some adjustments to the bank service areas would be appropriate. One of them is up here. You can kind of see here's the break between this is greater than 80, less than 80. Here's a big chunk of BSA 3 that goes out into the greater than 80, while the bulk of BSA 3 is in less than 80. Same with BSA 5, pretty good chunk here. These couple watersheds extends into the less than 80, as well as here and here. So we keyed in on those watersheds, and just to kind of to kind of show you how they matched up with these ecological section boundaries, you can see that this watershed up here, the BSA 3, is actually primarily over in this area, which is consistent with BSA 2. This particular area of BSA 5 actually occurs in the ecological section that is more consistent with BSA 7. This one that's in BSA 7 is more consistent with the one in BSA 5, I guess, consistent with the ecological section of BSA 6. And you can see down here, this area is all one ecological section. So after kind of looking through that, and I'm not going through all the details here, but just to kind of cut to the chase, we have a proposal that, well, it's something that we're going to propose anyway, and we've already shared this, I think, multiple times, is a new BSA boundaries, and also not only are they new boundaries, but they sort of make this split between greater than 80 and less than 80 pretty much follow the old county-based line with some changes, but for the most part, it was the closest we could get to match. And so, these are again, the key watersheds that we're proposing to move. So this one goes here from BSA 3 into BSA 2. This one would go from BSA 5 into BSA 7. This particular one would go from BSA 7 to BSA 6. And this one, Washington County in here, would go in BSA 7. So that's kind of, I kind of rushed through that, but that's in a nutshell what we're thinking in terms of changes to the BSA. Now, like, I just have to add, we did something, I mean, a little bit different, but similar in that we made changes way back in the day. We used to have a public value credit and new wetland credit, and we did a big kind of overhaul that affected a number of bankers, but we were able to put in some grandfathering provisions that, I think they worked pretty well. And that's the same thing we would propose here. We wouldn't just all of a sudden make this change and then all the bankers that have banks out there would be affected. We would propose some, generous grandfathering where those existing banks would be able to service probably a bigger area than they currently do in order to sort of make this work and to have a transition period. And so those are things that we're discussing and will be running by the stakeholders as well. But certainly we're not, if we move forward with this sort of change, we wouldn't be just throwing it in there and say, okay, effective immediately, your service area for your bank changes immediately. Like that's not something we would do. Just transitioning here to typing. So we don't have any statute change directly related to typing, but there was some, our executive order report, their 2016 legislative report, were really directed at improving mitigation outcomes. And we identified wetland typing as it relates to wetland impacts and replacements as something that we think we can make some improvements on mitigation outcomes and also improve efficiency in our program. And also recognize kind of the science that's involved. So I'm going to talk just a little bit about our proposal for typing. Statute now directs a TEP panel to use Circular 39 and coordinate. Plant communities were added to WACA rule in 2009 primarily for consistency with what the Corps was going with. And of course, there's complications with all these systems, and even Circular 39 in particular is a much outdated system. We're probably the only state that does anything with Circular 39 anymore. And along the way, of course, HGM has become kind of the system now that everybody has gravitated toward, and there's some strong science behind that. And even our wetland inventory update that was done a few years back now includes these HGM descriptors. The coordinate classification system has incorporated a whole section on HGM descriptors. And basically everybody's moving to more of an HGM-based system for a lot of things, and we're proposing that for mitigation credits and impact assessment. What is HGM? I think a lot of you are probably familiar with it. We've been teaching it in our wetland courses. It talks about, classifying wetlands based on their geomorphic or landscape position and the hydrologic characteristics. And there's basically 7 general groups: depressional, riverine, mineral flats, organic flats, tidal fringe, which obviously is not applicable here, lacustrine fringe, and slopes. And if you're familiar with the in-kind requirement in WACA rule, we have currently in rule, there's 2 systems that are referenced. In-kind can be the same plant community or same HGM. It doesn't say HGM directly, but it says landscape position and hydrology. So HGM, it's been shown to have more sound functional surrogates than plant communities. Plant communities obviously are a reflection of current conditions, not historical conditions. So if somebody impacts a wet meadow, it may be a degraded wet meadow, maybe historically that was a shallow marsh or deep marsh. So you're not really getting at sort of historical or natural conditions when you just look at plant community. And as I'll show you here, there's a lot of complexity and inconsistency, and we spend a lot of time trying to predict plant communities for restored wetlands just so we can classify credits. So as probably all of you know, if you look at any individual wetland, it's not uncommon to see several different wetland plant communities. And then of course, just drawing these boundaries of the different communities is imprecise at best. Looking at something with a few scattered shrubs, at what point, does the shallow marsh or wet meadow start and the shrub car end? Imprecise. And of course, we end up with wetland bank plans that look like this, where we have, these are just predictions of different plant community types that may develop after restoration. And you can see, there's multiple types identified at a fine scale, very precise acreages, and then these all get translated into credits. And of course, what actually happens out there is yet to be seen. It's almost never what's predicted. So we end up with very complicated credit release schedules, as many of you are probably familiar with, just because of the different plant communities. You can see we got different plant communities, different types of credit generation actions, and different credit ratios. And then, of course, you apply those to the numbers, and then you got all these different credit releases. It becomes this is a big table with a lot of information, about somebody going out and maybe breaking a tile and restoring a wetland. So we spend a lot of time on that. That's a cost to the public, certainly to bank plan developers, regulated parties, and the regulatory agencies. We spend a lot of time evaluating those. And of course, when you have something like that, that's hard to predict anyway, it's difficult to maintain consistency between the state and federal programs when we're reviewing these type of things. And simply put, I think, the mitigation plans using plant communities require a level of precision that we just don't have. And there's just considerable uncertainty about what plant community types would ultimately return. And really, in the end, the plant community types are determined primarily by hydrology, and most sites are designed to restore hydrology. Plants just sort of come along, those ones that are adapted to the hydrology that's restored. So we did take a look at the time. It's been a few years now, but we did take a look at what other parts of the country we're using. Here you can see an example from Iowa, and here's one from North Dakota, and you can see their classification is much more broad: pothole, emergent wetlands. So they're not using something as precise as plant community there. Looking at 9 other core districts, 3 were using a broad version of the coordinate system, like a PEMC or a PMB. 1 used HGM. 2 districts used kind of combination of both, and 3 of them used a district-specific or hybrid system, but again, based on much broader classes than the multiple plant communities that we have. And, I think this has been around for a number of years now. While vegetation may be easily measured, it's a poor indicator of function. And the National Academy of Sciences was really it resulted in the federal mitigation rule, or informed the federal mitigation rule, emphasized the need to promote naturally variable hydrology representative of other comparable wetlands in the same landscape setting. In situations where direct in-kind replacement is desired, mitigation sites should have the same basic hydrological attributes as the impacted site. Again, these are concepts that are embedded into the HGM system. So I think just from a logical perspective, if you're looking at a floodplain down here, a wet meadow in this floodplain functions way different than a wet meadow in a prairie pothole up here, for example. So the difference is from a functional perspective, and if you want to get in-kind replacement, I mean, they're really less about the plant community and more about, is it a floodplain, or is it a prairie pothole? Is it a mineral flat, organic flat, etc. So advantages of the HGM, again, it's related based on more of the abiotic factors that correlate well to wetland functions. So HGM-based descriptors have been developed nationally, as I mentioned, by the coordinate system. Ralph Tyner developed those, and we did use those regionally for Minnesota when the DNR updated the NWI. We have keys, decision trees developed. The HGM type doesn't really change over time, generally stays consistent. There's usually only 1, maybe 2 HGM types per wetland for the most part. And so, I mean, in general, it's just certainly it's something that would be easier to work with. Here's an example of the descriptors that were used in the Minnesota mapping, and that the terminology is a little different. There's some definitions, but I did work with DNR staff at the time, and we came up with a little crosswalk here. So essentially, the information that's in the NWI could be easily translated into a basic HGM class. So certainly that's an advantage, because most of those wetlands that are identified could just use the system that's already been identified. Just I thought this was interesting, not to get sidetracked here, but we did take a look at the distribution of the different HGM classes in Minnesota based on the NWI, and just as you might expect, like 25% of the wetlands out there, the polygons, contiguous wetlands, were depressions, but because they're smaller, they only covered like 8% of the acreage, overall wetland acreage. Whereas if you look at like an organic flat, only 7% of the wetland polygons are organic flats, but yet they comprise 22% of all the acres. So you can see basically we've got some of these that there's not a lot of them, but when we do have them, they're big. Some of these, there's a lot of them, but they're very small. But you can kind of see how they're distributed throughout the state. And so we do have, we do have a version of this on our website now, on Bowser's website. We do have a HGM classification system that has definitions, and there's dichotomous key that goes through and helps folks key out to a HGM type. It's pretty simple key. I mean, obviously there's some judgment involved, but folks can key it out. Also, they can rely on, to a certain extent, the NWI map and the system that's already been identified. So potential rule-related actions. So we were proposing to clarify the use of the HGM system for credit and impact tracking in WACA rule, include a definition and categories. I think looking ahead to the future, what we'd like to do is really convert, all those provisions in rule that are related to particularly Circular 39 and just get those over to use the same system that we're using for credit and impact tracking. But that would affect the de minimis exemption, so that's not something we could do without statutory changes or restructuring of some of those exemptions. But certainly something from our perspective on implementing the program, it would make it easier to have a single definitive system that we think is supported by the science. Wetland buffers, we don't have any definitive proposals at this time, but I'm just going to show you a couple of things that we did talk about with the Army Corps, and I think we have general agreement. A lot of times we're not getting enough buffer in areas with high land values, which would make sense. And sometimes we get too much buffer in areas of low land values. Folks just want to wrap it in and get credits because it doesn't have a lot of value for them. And then we have limitations on the amount of buffer and the amount of credit for buffers associated with banks. And that discourages, for one thing, restoration of small prairie pothole complexes. So those are some of the issues we would like to do some changes to help, at least help alleviate. And just for illustration, you can see, for example, if we have a area that's proposed to restore some prairie pothole wetlands, if we just apply the buffer, standards as we have them now, we end up with these little wetlands that are surrounded by their own little buffer, and there's really no connection. And of course, from the perspective of the landowner, that makes a lot of these areas not usable anymore. So if we could find a way when it makes sense to basically tie, like for example, a prairie pothole complex together and be able to credit this area when it benefits the overall wetland functions. That's something we would like to do. We talked about a number of ways, and I'm not going to go through all those potential things, but we haven't really settled on a firm proposal. At this point, we've just been sharing that it's one of the things we would like to propose, but we haven't got a proposal for anybody to react to at this point. And then the second thing we would like to be able to do, if, for example, if we had a wetland here that was proposed to be restored, and say there was a field in between, and then there was a corridor, say a stream, in this case a forested stream corridor. Now, if we just applied the current buffer standards, you might have a little bit here, but you would have this gap in between. So is there a way that we could wrap in and connect, say, a restored wetland to a corridor, such as this, a naturalized corridor, that would allow this to get some credit and just enhance the overall ecological value? So I think there's general agreement among the agencies this would be a good thing to see if we can do. It's just the devil's in the details of how you carry that out. And so that's another thing that, you know, look for some proposals at some point to maybe at least a little bit get to this and allow, maybe allow this to happen, because folks aren't going to do it if they're not going to get any credit, you know, if they're limited by the amount of buffer credit. So we're looking into ways that we might be able to do that. Am I doing on time here? We're towards the end here. Up to, so we're going to look at the wetland bank approval process. If you remember, I showed you how the wetland bank approvals had been struck for things that the LGU must make a decision on. So that leaves an opening for example, Bowser or some combination of Bowser and LGU to approve banks. And related to that, you know, we have about 40 up to 40 bank projects initiated each year. So there, you know, we have 250 some odd LGUs. So, you know, any one LGU is not going to see a lot of bank applications generally. So that, you know, it's hard to manage a lack of workload if you just all of a sudden get hit with a couple banks one year and the next year you don't have any, or you may not have any for years. And of course, as those of you who've been through the banking process, Bowser plays a big role in that, because we have to also accept the conservation easement, and we put a lot of time and effort in reviewing those, particularly from an engineering perspective. And you know, we've heard from a number of local government units that are sometimes frustrated with the amount of workload and the complexity of the wetland bank plan applications. There's no doubt it's become more complex and a longer process, and that not only affects the bankers, but it just, you know, affects the local governments that are tasked with reviewing that and shepherding it through the process. So here again is the statute change. And so we've been looking at and we've been sharing with our stakeholders some goals on the new approval process. We want to try to improve consistency, minimize redundancy, kind of reduce or stabilize LGU workload, still utilize that local expertise, and continually to look at streamlining the process. So with those goals in mind, we have worked through, we did this with the technical group back in 2018. We looked at different options. For one of those is the status quo. We just leave it as is, and the LGU makes all the decisions on the bank plan, except the easement acquisition. That would still be Bowser. There could be a dual approval process where the LGU makes decisions, say, at the prospectus phase, and Bowser makes a decision on the final bank plan. There could be a site certification. So the LGU could certify the site suitability and consistency with local plans, and Bowser would make the final decision on the bank plan. There could be some kind of veto authority where the LGU could essentially veto or deny based on site suitability and consistency plans, but otherwise Bowser would make that decision on the technical merits of the plan. Bowser could just simply make the decision. The LGU would just serve as the TEP member, and of course they would have appeal rights. And then there could be a situation where we just basically we could let the LGU choose whether or not to make decisions on bank plans. I know there's a number of LGUs out there that have expressed they don't really want anything to do with it. It's too much of a workload. They don't get enough of them. But when they do, it's onerous on their sort of regular day-to-day duties, and they would like to see Bowser do it. There's other LGUs that would like to retain it. So this could be an option for those LGUs that want to basically waive it to Bowser and others that want to retain it. So those are the kind of options that we've been discussing, and we've got some feedback on that, and I'm sure we'll get some more. I'm just gonna skip over some of this here. Already talked about functional assessment. So the last thing here, if you remember, I talked about the high priority areas and how we were going to wait on that. And one of the reasons we were going to wait is because we're in the process of developing an in lieu fee program, drafting a final instrument, and big part of the process of these compensation planning frameworks, which are really prioritization of wetland mitigation to meet watershed-based needs. And they're required for any in lieu fee program. And we're just about done with the state. And we intend on using these documents to help inform the designation of high priority areas. So where we're at now, this is a little outdated, but essentially you can see here, these green areas have been completed. I should have checked with Dennis before this, but we're either done with the rest of these are almost done, and then the rest of these are just being started. So the schedule is completion by 2024. So, at that point, we'll have these mitigation prioritization documents available for the whole state. And we're going to be using those to prioritize our mitigation for the local road program. But we're also going to make these available, and other folks can use them for developing banks or whatever. But ultimately, we'll have to use those to inform our high priority areas and adopt rules accordingly.
Ken?
Yes.
Is the CPF primarily developed internally at Bowser, or who weighs in on that when those are being developed?
Yeah, we assemble a group of folks, watershed districts, county folks, SWCD, like kind of the usual suspects of folks interested in natural resource planning and stuff in there. We have a kickoff meeting there, and Dennis is the one that's heading this, but they're allowed opportunities to comment and identify the watershed priorities and that sort of thing. So, but once all that's done, then it's more of a GIS driven exercise, looking at existing conditions and watershed goals, and identifying priority catchment areas for wetland mitigation to achieve watershed goals.
Okay. And then Karen Wold had a question in the chat about CPF as well. And then there were a couple of questions related to HGM that I don't know if you want to cover now or perhaps at the end. And Karen's question was, will CPF high priorities be adjusted if BSAs change, such as Washington County becoming the BSA 7? Would that impact the CPF?
Yeah, well, I guess that remains to be seen. I don't know. I mean, we were aware that sort of these things were happening at the same time, but we needed to get the CPFs done, you know, before we were going to make these changes. So I'm not sure. I'm sure we'll figure out some way to handle that, but yeah, it's a good question.
Do you want to hold those HGM questions for the end, Ken?
Sure, I just got 2 slides left, so
Okay.
let me just do those. So the advisory committee meetings, said we've had 2 of those. We're going to have another one here in another month or so, and then we're going to start developing some draft rule language and amendments, obtain some feedback, then we'll run it through some more advisory committee meetings, and at some point sort of finalize at least a draft, and then that goes to the Bowser Wetland Conservation Committee, makes a recommendation to the board, and then at that point we get into to the more formal process. But we still have a ways to go. We're still in the early stages. You know, we haven't really got any draft language per se at this point. We're working on that right now, and we're still basically kind of throwing out these concepts and potential proposals to, you know, our advisory committee and posting those on the website and getting the feedback as needed. So here's kind of schedule. I think we're already a little bit behind on this already, but we are in the wetland outreach stakeholders. This is 2022. We'll be drafting the rule and then going through that advisory committee meetings again, probably the winter of this year, 2023. And then making final drafts and sonars and seeking board authorization to adopt sonar. You know, then that's followed by a publication of notice and draft in the state register. Then the whole issue of hearings. In 2008, 2009, we had several hearings around the state. They're not required. We may or may not have hearings. If we do have hearings, then that delays the process or lengthens the process considerably, because we've got to arrange all those hearings. So it remains to be seen if there'll be any of those formal hearings. Like I said, I think we did 3 or 4 in 08, 09. And those are hearings with an administrative law judge, and they're a little more formal than just say our stakeholder meetings. And then it goes through the wetland committee, the board. It also goes through, we don't have a bunch of the steps in here, but administrative law judge, governor's office is involved, heads of the Minnesota State Senate, state representatives have to review it, and a number of other people. And then at some point, maybe towards the end of 2024, you know, we can look at an official adoption of the rules. So it's quite a lengthy timeline. I will say that this is, you know, considerably longer than 08 and 09, and part of the reason is that they changed the rules on rulemaking, changed the rules on rulemaking between, I think they did it back in 2015. So that certainly lengthened the process at the end. We always have done a lengthy process at the beginning, which is where we're at now, but then sort of formal process at the end is now longer than it has been or was in the past. So that's it.
Great. So in the chat, Ken, somebody asked, what makes HGM superior to the Coarden classification?
Well, I think I just kind of went through those slides to sort of make that case, but you know, in a sense, I mean that the system, first of all, from a scientific perspective, I think has better correlation of the HGM type better correlates to the suite of functions that a particular wetland provides than do other systems. Also, you know, like I said, there's usually only one HGM type per wetland, whereas there could be 5, 6, 7, 8 different coordinate types within any particular wetland.
Yep. That question may have come in before you made your case all the way.
Okay. Yep.
Yeah. And then Karen also asked, so would we still identify circular 39 types for the purpose of de minimis exemptions? Should we identify HGM classifications on wetland delineation reports?
Yep. So circular 39, unless and until there's a statute change that eliminates those or change those for all of our de minimis or all of our exemptions or those exemptions that involve type, it'll still be used, right? I just kind of, what we're talking about is changing the typing system for replacement and impacts for wetlands. And that's something we can do because there's no statutory limitation on that. But we can't change it for the exemptions because those circular 39 types are written in statute in the exemptions. So we would like to find a way, you know, eventually go to one system, but until a statute change occurs, we can't do it. So circular 39 is still around and will be here until that happens.
If anybody else has any questions, you can feel free to raise your hand and I can unmute you, or you can type in the chat. If we don't see any questions, I'll pass it back over to Rebecca.
Sure. I think that's all that's come up. Sorry, it's hard to, there's so many people in here. It's hard to keep an eye on everybody who could possibly raise their hand, but yeah, that was a great presentation. Thank you both for joining us today and giving us all that info. Should people be reaching out to you guys with follow-up questions, or how would you like to handle that?
Yeah, I mean, we're, you know, me in particular for rulemaking, you know, I'm certainly willing to discuss or meet with people to talk about aspects of rulemaking. You know, that's what we're here for, and typically that's better conversation, you know, to have that as opposed to like a larger meeting. Right? It's just harder to get into the details. So I welcome that. You know, you know where my email is, and certainly contact me or Les.
Okay, sounds great. I don't see any more questions coming in. Do you?
I don't see any either, but Jason Husbeth wanted to make an announcement, and I should be able to unmute yourself now, Jason.
Yeah, I can. I just wanted to make a brief announcement. We offer every year a sedge identification workshop in June. It's gone from 2 days to 3 days as of last year. June 14th and 15th are the lab days at the U of M St. Paul campus, and then June 16th is a Friday. We meet all day at William O'Brien State Park. It has been approved for 18 CEUs through the WPCP program, and there's 25 spots with about 20 remaining. You can access information on our website, ccesinc.com, workshops. And I'm going to work with the WPA to get this announced in the emails. So if you are interested in attending, you can reach out to me and we'll get you registered, and that's about it. So and then the other thing is it's a detail, but we do work directly with the WPCP to make sure that your credits are registered once you attend the class. That's it. Thanks.
Perfect. Okay, well, I think with that then, thank you for presenting to us today, and hopefully we'll see everybody again in February at our next forum, which we're still sorting out the topic for. So